I'm Jan Meisels Allen. I chair the IAJGS Public Records Access Monitoring Committee. Most of you have seen my postings either on IAJGS or Jewish Gen. And so I don't think we need to give long introductions. Randy, who is here, will be talking for himself. He is, as most of you know, Ryan Reynolds' doppelganger. So he will be talking later. This is Privacy in Genealogy. What are the rules? Privacy. Someone's right to keep their personal matters and relationships secret. If we're not able to access links on search engines nor access the historical record, where does our genealogy leave us? With a paucity of historical documents and sites and the lack of depth for knowledge and understanding why certain occurrences happened and about the people who did them, is this as important as whether someone wants to be removed from one's tree, whether to place the tree on the internet, collaborative genealogy? Now, if we continue to have governments and courts limit our access to records, internet sources, and historical documents, we won't have to worry if we should share, post, collaborate with, remove a person or a reference from our trees, as there won't be information to include on our trees, and they will be stagnant at the point when we could do all those genealogically important functions. And as you see on my little sign here, the archives are closed today. We are seeing more and more archives and libraries limiting access because they have to close due to budget restrictions from the government. Do the dead have privacy rights? In the United States, and first of all, I am not an attorney. I am a retired lobbyist, but I was the only non-attorney in the lobbying department for the organization I worked with. So I'm very familiar with laws and regulations and how to interpret them, but I'm not a lawyer, so I'm not giving you any legal advice. Legally, in this country, the dead have no privacy rights. However, governments embargo death records for any number of years, from 0 to 125 or more. Who are they protecting? The person is dead. Access to the death record may save lives by being able to trace back genetically inherited diseases. And when I lobby, I use this very, very often to explain it is important to know the illnesses that our ancestors have, so that those of us who are living and for future generations to come, we can take the appropriate medical actions to try and either prevent or ameliorate whatever condition we might have inherited. The recent adoption by the European Union of an updated protection regulation, it's a privacy regulation, expressly states the right to be erased or the right to be forgotten does not apply to the dead. In 2015, the New York City Department of Health came out with a ruling which limited which family members may access death records. And in addition to that, they went into the New York Public Library and took off volumes, I won't even say how many, volumes and volumes of books of the death and birth records that had been there for years. So if you are not, on the death record in New York City, if you are not the spouse, the child, the grandparent, or the grandchild, you can't get it. You could not get your great-grandparents, you could not get your aunts or your uncles or your cousins' death records if they died from 1949 on. Whom are they protecting? What do genealogists do that contradicts keeping our information private? We post and we search. We search online. Our search history is archived by search engines. We post online. If you put my name into Google, you will find thousands and thousands of posts that I have done over the years. So anybody can find me. We blog. The IAJGS Records Access Alert is an announcement list because you can't respond on it. But it's basically a blog, a one-way blog. So you can find me. We use social media, Facebook, Twitter, Snapshot, YouTube, LinkedIn, and Flickr. Everything we do is out there. So where is our information posted? It's posted on the internet, articles and newsletters, social media. Some of us put our trees online. Some of us can be found in search engines. But it's an individual's choice whether to post or to participate on social media sites. Social media is not private. Have you ever regretted something that you posted and you can't withdraw it? It's there forever. I'm not saying not to use social media, don't get me wrong. I'm just trying to show you how our own information, our own private information gets out there, and we're the ones who are doing it. Okay, this quote is from the leading fraud prevention service CEO in the United Kingdom. The likes of Facebook, Twitter, LinkedIn, and other online platforms are much more than just social media sites. They're a hunting ground for identity thieves. We are urging people to check their privacy settings today and think twice about what they share. Social media is fantastic, and the way we live our lives online gives us huge opportunities. Taking a few simple steps will help us to enjoy the benefits while reducing the risks. To a fraudster, the information we put online is a gold mine. By show of hands, how many people who are here have put down, since you've been here on Facebook or Twitter, something about that you're in Orlando? You have now told everybody that you're not home and your house is available for theft. Save the photographs till you get home and you're there. I'm just showing. We all do it, but we don't think about some of the implications. Okay. Many people tweet. So what you say to tweet is here for perpetuity. As of 2010, the Library of Congress has acquired Twitter's entire archive of tweets and is planning to make it all available to researchers. They have a problem. As of 2012, there were 20 billion tweets, 500 million a day, and I can assure you in the 5 years since, people are tweeting a lot more than 500 million a day. And we all know one who uses it a lot. Facebook puts different privacy levels out. When they change their privacy level, you have to change your security level or you might be vulnerable. And remember, you're only sharing your information with your friends and family, but one of those friends and family are taking what you posted and sharing it with their friends, and they're going to share it with their friends. Again, I have nothing against social media. I'm not saying not to use it, but I'm suggesting if you want some things not to be ubiquitous, think about what you're doing and how you're doing it. Okay. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. You notice that the right to privacy is not mentioned in the U.S. Constitution. However, the Supreme Court, beginning as early as 1923 and continuing through its recent decisions, has broadly read the liberty guarantee of the 14th Amendment to guarantee a fairly broad right of privacy that has come to encompass decisions about child rearing, procreation, marriage, and termination of medical treatment. Now, I'm going to talk a bit about the European Union. I understand that most of us in this room live in the United States. I guarantee you that 95% of us in this room have ancestral heritage from one of those 28 countries. Whenever I post about the European Union and the right to privacy, I am guaranteed within 24 to 48 hours I get 3 unsubscribes because it doesn't pertain to me. It pertains to us. Listen, first of all, we're in a global world, and what happens there or what happens here goes this way. And I'm going to show you that the right to privacy is here. And we don't like it because we're used to freedom of speech and freedom of press, but it's here. And I did say 28 because while the United Kingdom says it's Brexiting, it's leaving, it hasn't left yet, it's still got 2 years to go. There's a fundamental difference between the European Union and the United States. in the European Union, privacy takes precedence over freedom of speech and press, while in the United States, we have the constitutional rights of freedom of speech and press, which is a priority over an individual's privacy. The right to be forgotten basically started in 2014 with Europe's highest court, the Court of Justice of the European Union, which ruled that individuals could ask a search engine. I put Google down because the court case specifically mentioned Google. It dealt with Google. Understand that in the European Union, while it may vary by country, but as the 28 countries as a whole, Google has 90% of the search engine business in the EU. So they are the elephant in the room. So all the court cases really are against Google when they talk about search engines, but it applies to Yelp, it applies to Bing, and it applies to the local search engines as well. Excuse me. And they ruled that individuals could ask Google, all search engines, to have a negative information removed or delinked or delisted from search results. The ruling did not affect the original source, just the search engines. It started with a Spanish attorney who found when he put his name into the Google search engine that he could draw up some old articles when he had declared bankruptcy. And he thought it was affecting his business. So he went to court and he wanted both the articles to be removed from the newspaper as well as from Google. And it ended up at the Court of Justice of the European Union. And what they found, the original source can stay. But the search engines, if it's something that, and they gave a whole bunch of different reasons for derogatory or old, not relevant anymore, they could petition or request the search engine to remove it. So the decision is made by the search engine whether or not it should be removed, not a government agency, at least not yet. And since May of 2014, Google has received just under 700,000 requests to have from 2 million links removed, and Google has declined 57%. And if you do your math, that means they approved 43%. And then they further limited the right to be forgotten in 2017, saying individuals cannot demand that personal data be erased from company records. There was a court case from Italy that ended up there because they had company records and they had people's names, and there was a negative because this person didn't do something right in the company records, and they found for those types of things they could not ask for the right to be forgotten. Okay, now we come to our friend in France. And there was a local court that decided that Google should delink on this particular gentleman. Again, it was another attorney who had a problem. But the local court said it should be delinked worldwide, wherever Google operates. So what I say in this French court affects Israel, affects Argentina, affects the United States, affects Canada, affects wherever Google operates. And the French data regulator, known as CNIL, decided they were absolutely right. So Google takes them to court. And it goes to the highest administrative court in France, who was getting deluged from everybody who was saying, you know, newspapers, right to press, right to free speech. What does one country have to say about another country? So they punted it. And who did they punt it to? They punted it back this month to the European Court of Justice. The Court of Justice of the European Union. Again, that is the overarching determination for all the European Union nations. And so we will see if President Macron will become the head of the Internet, saying that what France says must go in all 192 countries. In Belgium, they extended the right to be forgotten not just to search engines, but to newspaper archives. But that's only in Belgium, but it's a chilling effect. Okay? And now we go to our neighbor to the north, our dear friend Canada, who last month, their Supreme Court decided, again a case with Google, that Google has to delink globally, all 192 nations or as many nations as Google operates in. And this was a case from British Columbia, and I'm not saying that the court was wrong in the local court saying that Google should delink, and Google delinked 390 some odd sites in Canada about this, because what the bad guys were doing was illicit. And there's no guarantee that the bad guys were going to listen to the court and say, please don't do this outside of Canada. So the court decided then Canada will determine you can't have this anyplace. Well, Canada doesn't, the last I heard, doesn't go outside its borders for laws, but now they're saying they do. So in addition to President Macron may decide what the internet is, we now know that Prime Minister Trudeau definitely has it because his Supreme Court has said what we say goes to all 192 countries. If Google has to delink it here, they have to delink it every place. So tell me, with 192 countries on the globe, which international body can adjudicate between all the different cultures and all the different laws? To my knowledge, there is no such court. And I guess I wasn't just pontificating because this week Google went to the U.S. court in California. Google is home-based in California and has asked for an injunction stating what Canada is telling us to do is a violation of U.S. law called the freedom of speech and freedom of press, which is the First Amendment. So stay tuned. Now, if you don't think it's here in the United States, you're not reading my IAJGS Public Records Access Alert, because in New York this year, we had two bills to introduce the right to be forgotten, one from the Senate and one from the Assembly. The senator finally had the light bulb go off and say, gee, it is a violation of our First Amendment rights, I'll withdraw the bill. The Assemblyman has kept it and has gotten support from a group called Consumer Watchdog. So tell me if this gets through, which I doubt, but how can New York State tell a California company such as Google or Facebook that they can't do something, or a Washington State company like Microsoft that they can't do something? I don't see how that's possible. Yet there's a court case now in California before the Supreme Court for Yelp. There had been these two people. One person wrote a defamatory thing on Yelp. The court told that person to take it down and has refused. So they said, Yelp, you have to take it down. Yelp wasn't party of the litigation. So they are appealing this to the Supreme Court in California, because having the platform do it is also a violation of the Internet law, which is a federal case, federal law. Okay. California also passed a law several years ago that says that people under 18 can have things that they posted on the internet removed, and I can understand that because we were all young once, and sometimes we did do things that were too smart when we were young. The Consumer Watchdog, who was supporting the Assembly bill in New York, has already gone to the Federal Trade Commission and has asked for right to be forgotten to be enacted here. And right here in Florida, the Tampa Bay Times editorial board has instituted the right to be forgotten because they got petitioned by a reader who said, you have things in the archives which are no longer relevant. It was so many years ago. Please take it down. So it's here. The right to be forgotten worldwide has been adopted in Argentina, India, Mexico, Peru, Russia, South Korea, and Turkey. Brazil has said not for search engines. A lower court in China says, in Beijing says, no, we don't have it. Indonesia says we don't have it for press institutions. And the Japan Supreme Court has counteracted four lower courts saying, no, we do not have the right to be forgotten here. Now, I mentioned earlier about the European Union has a data privacy regulation. It was enacted a year ago, May, and they gave each of the countries 2 years, so it becomes effective next May. Those 2 years, each of those countries are supposed to change their own country laws to become effective and compliant with the EU's data privacy regulation, so there will be one system across all 28 countries, and it codifies the right to be forgotten. It does not apply to the deceased individuals, which helps us if we want to have access about our ancestors, because most of our ancestors have passed on. It also does not affect Holocaust and war crime records. They have to be made available. And both for the issue of the deceased and the Holocaust war crimes, I will tell you that IAJGS contacted the Minister of Justice for all 28 countries saying the Holocaust victims have the right to be remembered, not the right to be forgotten, and that we need information on the deceased because of inherited genetic diseases, which I talked about earlier. I will also say that the International Holocaust Remembrance Alliance took a major, major role in making sure that the Holocaust and war crimes records to be made available. So we're very pleased that those two provisions in the General Data Privacy Regulations. It also stated that government and private repositories have a legal obligation to acquire, preserve, appraise, arrange, etc., and to provide access to records of value for the general public interest. So this means a local clerk cannot say, we can't give you access. You've now got a law that says they must give you access. All of the companies I mentioned earlier, Facebook, Google, Microsoft, they're international companies along with others, and they're under siege in the European Union. You know, they're the behemoth in the group. They have 90% of the market. They have 75% of the cell phone market. So there's a little bit of jealousy, shall we say. The European Union, both by country and by overall union, have litigation against all of these companies because they're perceived for various violations, whether it be alleged sharing of information, whether they're using a data cookie for tracking people, collecting information or transferring or storing data on European Union residents outside of the European Union. The French data regulator and the French court, which I mentioned, we're now going to the Court of Justice because they believe that they can do things extraterritorial. That was against Google. And then they also found that the court found that third-party websites like search engines without consent of the holder constitutes a communication to the public, so that they hyperlink. We all use hyperlinks. When we click on a link, that's a hyperlink. So that means that they didn't get permission, then they're in violation of the EU's copyright directive. And just this month, Germany enacted legislation with substantial fines for permitting fake news and hate messages to be posted. That affects Facebook, YouTube, and other sites that have at least 2 million German users in Germany, that they would have to remove these, quote, obviously illegal content within 24 hours after receiving a complaint or notification. Now, Germany is taking Google to the CJEU court on copyright infringements. How many of you go to Google and you find in the search engine and a newspaper article comes up and you click on the article? The German newspapers want to get paid for every time we click on one of those news links, and they want Google to pay them, and that is why they're taking them to the Court of Justice. Now, that affects our research because most of us don't know the original site of a story, but we use search engines for that. So it's a very major helping aid in our genealogy. The European Union Commission fined Google $2.7 billion for directing its users to its own shopping comparisons. So if I was looking for a black bag and it came up the first 5 companies to buy a black handbag, but it didn't have them sprayed out all the same way, and it didn't have some of the smaller ones, they're considering that's an antitrust action. Okay? They also fined Facebook 110 million euros over providing misleading information about its acquisition of WhatsApp. When they acquired WhatsApp, they said they weren't going to share user data between its parent Facebook, and after 2 years they did. And then they have CNIL, I don't want you to think I forgot about Microsoft. CNIL's France's data regulator served a formal notice on Microsoft asking to review its policy on collecting user information within 3 months and to comply with their legislation. Now, genealogists need to be able to locate stories about people, places, and events for our own family history. Some of our information should not be shared or posted, such as Social Security numbers. Some government agencies have placed embargo periods on birth, marriage, and death records far into the future, 25, 75, 125 years, while other jurisdictions have placed 0 limitations, and there are no documented differences in the rate of identity theft in those states that have open information or those with embargo dates. Genealogists do not cause identity theft, regardless of what our dearly beloved elected officials and regulators think. They hear genealogists, we're the identity theft. What causes identity theft is computer breaches at the educational, financial, government, medical, and commercial entities. We've all heard when TJ Maxx got hit. We've all heard when the banks got hit. We heard when the Department of Defense got hit. We've heard when all of these agencies got hit. I didn't hear genealogy in one of them. Now, this may or may not be controversial. Genealogy is changing for gender identification. Normally, we check off when a child is born male or female. And people are changing their gender, and that means that it could affect family group sheets, corrected birth certificates, delayed gender identification, genealogy database software. I'm going to give you some quotes from members of the Public Records Access Monitoring Committee to show that the interest is on all sides of the spectrum. Birth records are a staple for genealogical research. Family descent is the #1 priority in genealogy. Once vital records becomes politicized, the records lose their reliability. If someone doesn't want their gender out there, it's not our place to out them. But with social changes, we need to be able to address the options in our genealogy when they're public, and we could put them in the notes. With Cousin Sam saying, I'm now Cousin Sandra, that's fine as long as you have permission from Cousin Sam/Sandra to say that. It's not our role to make that determination. If they come out publicly and they say it's okay, that's fine, and I'll give you some examples in a moment. Recent changes in multiple jurisdictions for changing gender on birth records. In New York City and Oregon, they now permit intersex as the gender. Most states will change the gender on an original birth certificate if a physician's letter that a sex change operation has occurred. In 2016, Oregon was the first state to permit non-binary on a birth certificate, and similar legislation is pending in California. In Canada, they now have the first genderless child on a birth certificate. A transgender person is refusing to put down the gender of their child on a birth certificate because they want to wait until the child is old enough to determine what gender they want to be. This is causing all sorts of problems because you need identification for medical benefits in Canada, just like you do here, and it's blank. Genealogy is changing. As mentioned previously, we genealogists make our own decisions, what to post, Twitter, and place on the internet. Online genealogy companies develop privacy standards as part of their marketing strategies, not due to legal requirements, and I believe Randy's going to talk more about that. Neither in the United States, Canada, European Union, or elsewhere are there laws that restrict what can and cannot be included in someone's online tree. Only you decide what you want to include and whether to post it or not. So I'm suggesting that you also register for the IAJGS Records Access Alert. This is an announcement list for all public record access issues. These are no longer on the IAJGS Leadership Forum, and they are different messages than what I post on Jewish Gen. Jewish Gen will not allow me to post a bill that has not become a law or a regulation that's going to have a hearing or anything that's advocacy. Those are their rules. IAJGS, through the Records Access Alert, I can tell you this is a bill in your state, you might want to contact your legislator. I can tell you that there is a piece of legislation that is pending or a regulation is pending. I'm allowed to do that. That's the only place you're going to find it is the IAJGS Records Access Alert. There have been 227 alerts since last year's conference. And to subscribe, and I have some flyers here, you go to recordsaccessalert.iajgs.org, or you can send comments to me to pramc@iajgs.org. We recently revised our Code of Ethics, which is on our website, and I just want to take a couple of points on this. While understanding the privacy concerns of both the public and governmental agencies, IAJGS will continue to advocate for access to all records relevant to genealogical research. Individual genealogists should respect requests made by persons asking that certain information about themselves or family members may be kept private. More recent data should be evaluated in the light of sensitivities of the living versus the importance of disseminating information, and generally requests made to genealogical researchers should be respected when individuals ask that certain information about themselves or family members be kept private. We each have a personal decision to make. What do you do when a family member does not want certain information included in the family tree? This is your family. You want to keep a relationship with the family. If they say don't put it in, don't put it in. Genealogy is not there to hurt somebody. A lot of people, things have changed over time. At one time, having a child out of wedlock you didn't talk about. Today it's very common. But that doesn't mean for that individual that they want it out there. So you really have to ask permission whether this is okay to be put out there. We don't want to hurt anyone, so there's a compromise. And who or what should be included in the family tree and permission to do so is left to personal decisions. I was recently updating one branch of the family, and I knew 3 of them were gay. And I went out to them. I didn't say anything about their gender preference or anything else. And I asked them to update their part. 2 of them came back. They had since been married. One was had a lesbian wife. The other one had a homosexual husband. That's fine. They gave me photographs. They gave me marriage dates. They gave me all this wonderful stuff. Please put it into the family tree. The third person was silent. It is not my role for that third person to say anything, whether he's gay or straight. I just mention him, who his parents are, what his occupation is. I don't say anything else private, because his lack of response was a response. And it's our responsibility as genealogists to remember that we have a responsibility to ourselves, to our family, and to the public. Thank you.
Thank you, Jan, and thank you, everyone. I'll speak while I set this up, I hope. For those who do not know me yet, my name is Randol Schoenberg. I am a board member of JewishGen, this is the right slide, a founder of the Austria-Czech Special Interest Group. I'm a curator on Genie.com. I am the founder and administrator of the Jewish Genealogy portal, et cetera, et cetera. This is actually going to be an excerpt of a paper I delivered 2 years ago at the conference in Jerusalem. If you'd like to read it at your leisure and in more detail, go to Avotenu Online, where it's been published, and just look for privacy issues with online trees by me, and you'll find it there. Okay. The right to privacy is a relatively recent legal construction, actually, and one that is still evolving. As genealogists, people whose goal it is to learn about personal details of other people, we often hear complaints about invasion of privacy. So it's worth exploring, I think, the issue in some detail to understand what rights actually exist at present and what might evolve in the future. Since much of our work is done online, I'll also address privacy issues related to online trees on various platforms. Although Judge Cooley in his 1888 treatise on torts had argued for a right to be let alone, prior to 1890, no English or American court had ever expressly granted relief based on any right of privacy. However, in 1890, Louis Brandeis, a Kentucky-born lawyer in Boston with very Jewish roots in Bohemia, who later would become the United States' first Jewish Supreme Court justice, penned a Harvard Law Review article on privacy with and at the urging of his friend and colleague Samuel D. Warren. In The Right to Privacy, Brandeis and Warren argued that the legal principle of a right to privacy should be acknowledged under the law. And this was the first time that argument had been made. The impetus for the article, which is considered by many to be the most influential law review article ever written, might strike us today as actually rather quaint. Warren, who in 1883 had married the daughter of U.S. Senator, Secretary of State, and one-time presidential candidate Thomas Bayard, was concerned primarily with gossip columns. Here's an excerpt, which I won't read all of. Again, you can go online to read it. But he starts by saying, the press is overstepping in every direction the obvious bounds of propriety and decency. Gossip is no longer the resource of the idle and the vicious, but has become a trade. And reading to the end, modern enterprise and invention have, through invasions upon his privacy, subjected him to mental pain and distress far greater than could be inflicted by mere bodily injury. Now, no one really knows what specific gossip about the Warren family might have been the impetus for this, but they were close with President Grover Cleveland, who had had a child born out of wedlock, etc. And so who knows what caused this, but gossip was really the initial concern. The right to privacy, that article led to the development of 4 related but distinct categories of privacy rights, as delineated by University of California, Berkeley School of Law Dean William Prosser, one of the most famous law professors that we've ever had, in his seminal 1960 article on privacy. He listed these 4 different types of privacy protections. One is for appropriation. The first right of privacy to be adopted was the right against appropriation of name and likeness for commercial purposes. This right limits the ability of advertisers to use the names, faces, and voices of celebrities and others in films or advertisements without permission. This category could also come under the rubric of false advertising, since the purpose is to prevent misleading suggestions of celebrity endorsements, as well as protecting the rights of celebrities to profit off their fame by endorsing products. The second right is intrusion. The right of privacy has been used to bar physical intrusion, searches, eavesdropping, wiretapping, and hidden sound and video recordings. This aspect of privacy requires an affirmative act of prying or intrusion that a reasonable person would consider objectionable, and the thing intruded upon must in fact be private. For example, it is not an intrusion to watch, follow, or even photograph a person walking on a public street, although it would be to use a selfie stick to film up a woman's skirt, right? So that's the example. Public disclosure of private facts. A cause of action can be brought for objectionable publicity given to private information, even if true. A 1931 case involved the revelation of the present identity of a former prostitute who had been a defendant in a murder trial 7 years earlier. Other early cases involved publication of a person's debts. The facts must be private facts, not generally known to the public, that are offensive or objectionable to a reasonable person of ordinary sensibilities. And we'll get back to this one. The fourth category is false light in the public eye. In these cases, the invasion of privacy is a result of attributing to the person some generally embarrassing or objectionable attribute that he does not actually hold. For example, if one were to take a picture of a random person and place it in an article on syphilis sufferers, this would be considered an invasion of that person's privacy. This category is perhaps quite similar to the law of defamation, since it applies only to false and misleading attributions. Now, of course, there are limitations and defenses to an action for invasion of privacy, most notably the common law privilege and in the United States constitutional right to report on and discuss public figures and events of public interest in the press. For public figures, such as politicians and celebrities, there is no invasion of privacy unless there is a finding of malice, which is to say an intentionally false and misleading publication of a private matter designed to harm the subject and not for the legitimate purposes of parody, opinion, or public comment. I've gone into this detail in order to demonstrate that mostly what we call the right to privacy has little or nothing to do with what we do as genealogists. Certainly the first and last categories, appropriation and false light, have no possible connection to genealogy, since we are not in the business of using people's names for commercial advertisements or films, nor do we intentionally add false facts to our family trees in order to embarrass people. Intrusion also would not ordinarily be an issue of concern unless you're in the habit of using unorthodox methods of obtaining genealogical data. For example, I suppose hacking into private adoption files might give rise to an action. But barring something egregious like that, the only possible category that could concern what we do when we build family trees is the one pertaining to public disclosure of private facts. Before we delve further into the right against public disclosure of private facts, I want to suggest that in my personal opinion, this category is ripe for reevaluation. The old cases that first gave rise to the concept increasingly seem old-fashioned and out of date. What we often do when we limit disclosure of private facts that ordinary people deem offensive and objectionable is perpetuate stigmas. Promiscuity, homosexuality, illegitimacy, infidelity, etc., were long considered so objectionable that the mere mention of the fact, even if true, was considered offensive and an affront to public morals. By limiting disclosure and discussion of these facts, the stigma was in fact reinforced. Their absence from the public sphere made their occurrence seem more rare and unusual than they in fact were. Yet the considerable change in public opinion on these issues has demonstrably been the result of more disclosure and discussion. For example, the controversial practice in the 1970s of publicly outing prominent homosexuals under the protection of the reporting privilege no doubt led to the great advances for the homosexual community that we have seen in the past decade. Disclosure can lead to the erosion of the very stigma that makes the fact objectionable by making the presumed deviant behavior more apparent, even ubiquitous, and therefore less threatening. We need to be cognizant of this when we consider the rights of individuals to prohibit public disclosure of private facts based on the current state of public mores. Protecting privacy in some cases reinforces the need for privacy by affirming the stigma attached to an otherwise unobjectionable fact. That is not to say that there is no need for privacy, and the law already delineates a number of areas where privacy is protected and disclosure cannot be compelled. For example, the attorney-client privilege, or the doctor-patient privilege, or the penitent priest privilege. All of these conversations with between married couples, all of these are prevented from forced disclosure under the law. Same, for better or worse, applies to tax returns. Okay, turning now, however, to genealogical data. The existence of legal protections are much less clear. Are there, in fact, any legal limits on what we can and cannot publish on a family tree? Okay, let me go further here. Let us first attempt to differentiate between living and deceased people. Do the deceased have privacy rights? And if so, how are they protected? Since dead people cannot assert rights for themselves, this question is related to the question whether privacy rights can be asserted by heirs on behalf of someone who is deceased. With regard to the right against misappropriation of likeness, the common law did not extend to heirs any rights to assert a claim. In one case, in California, the heirs of the actor Bela Lugosi claimed profits from Universal Studios for exploitation of Lugosi's Count Dracula character. The California Supreme Court denied the claim, finding the heirs had no common law rights to prevent use of Lugosi's likeness. California subsequently passed legislation giving heirs rights against appropriation of the celebrity's name or likeness for 70 years after death, and other states have enacted similar protections. However, no statute has extended such inherited rights to claims for public disclosure of private facts, which, as we demonstrated above, is the only aspect of the right of privacy that would pertain to genealogy. Therefore, absent new legislation, there is no right of privacy issue with regard to disclosing facts about deceased individuals. This means that, as far as the law is concerned, genealogists should feel free to disclose genealogical data and even embarrassing facts about the deceased. No legal claim can result from such disclosure. With regard to the living, the rule against public disclosure of private facts applies. Okay? The facts privileged from disclosure must be private facts, not generally known to the public, that are offensive or objectionable to a reasonable person of ordinary sensibilities. Regular genealogical data regarding name, date, location of birth, marriage and death, the name of the parents, siblings, spouses, and children should almost never give rise to any claim for invasion of privacy, since these facts are usually not private, but are known by a wide range of people, and further are not offensive or objectionable to a reasonable person. As Dean Prosser explained in 1960, quote, "No one is entitled to complain when there is publication of his recorded date of birth or his marriage," end quote. With regard to some embarrassing private facts, however, the genealogist is probably wise to tread with more caution. If it is not generally known that the milkman was your cousin's father, it is probably not wise to publish that fact. By extension into the modern world of DNA testing, disclosing that a father does not share the Y-DNA haplogroup of his putative son could in fact be problematic. This is not to suggest that liability will result from the disclosure of any such facts. There may be defenses in any particular case, and the existence of damages from an objectionable disclosure might be uncertain and may depend on how many people will have seen the disclosure. Remember that the test is not whether the supersensitive subject objects, but whether a reasonable, ordinary person would find the disclosure objectionable. Even the milkman example might not rise to this level, especially if the publication was for the purposes of a family tree. There are today not many genealogical facts that the ordinary person might find truly objectionable if disclosed. Adoption, homosexual relationships, out-of-wedlock births, and in the wake of Bruce Jenner, even gender transitions may now be safe to disclose, as the stigma previously applied to these facts has receded. By contrast, the public disclosure that a birth was the result of rape or incest might still be thought sufficiently objectionable and may give rise to a potential for liability. A genealogist should use his or her best judgment in these cases, but there is no hard and fast rule to rely on. I want to repeat again that the objection of the individual concerned is not relevant to the legal question, so long as the fact itself is neither private nor objectionable to an ordinary, reasonable person. Genealogists commonly hear complaints from people who fear the disclosure of their birth date or their mother's maiden name, often because of an irrational fear of so-called identity theft. The truth is that what is commonly called identity theft is in reality just garden variety fraud, and it is accomplished without the use of genealogical data. The most prevalent type is the result of theft of credit card data from merchants. The thief steals the credit card information, usually in bulk form from a computer file, and uses it to make a purchase. No family tree information is ever utilized. The other type of identity theft is when someone applies for credit in your name. This type of fraud is perpetrated ordinarily by a bank teller or someone in your home who already has access to your mail, phone, address, date of birth, and social security number. Again, no search for genealogical data is ever involved. As far as I've been able to determine, there has not been even one documented case of identity theft involving a family tree. Not one. So, to return to the question, an individual's irrational fear of identity theft should not give rise to any claim for violation of the right to privacy against a genealogist, because an ordinary, reasonable person would not have such fears, as the true risk of damage or embarrassment is zero. This means that as genealogists committed to public genealogy, as I am, we should feel free to ignore the objections of those with irrational fears about the disclosure of commonplace genealogical facts. At least from a legal perspective, we have every right to disclose those facts. They are neither truly private, nor are they objectionable or damaging. Private facts do not include information that has been voluntarily disclosed to a third party or knowingly exposed to the public. Many people know your date of birth. Think of all the birth announcements and everyone who ever celebrated your birthday with you. Your mother's maiden name is also known to a wide range of people, namely everyone who ever knew her, at least prior to her marriage, or who also knew her parents. These facts may be published because they are not private in any sense of the word. Compare them to the truly private conversations between the attorney, client, doctor-patient, spousal, or priest-penitent privileges. You cannot make an otherwise public fact private merely by wanting it to be private. As a result, with few exceptions, ordinary genealogical data may be published without giving rise to any potential claim for invasion of privacy. Let me check the time, 4:20.
We go to a quarter of 5.
Okay, so I'm going to go for a few more minutes and talk about online trees. I talked about European rules in my paper if you want to look online, but Jan has covered that very well. Okay, what about online trees? Multinational corporations who do business in both the United States and Europe are facing a dilemma of how to react to increasing demands for online privacy. Google and Facebook are, of course, at the forefront of this battle, but they're not alone. Genealogy sites such as Ancestry and MyHeritage and Genie all have to tread very carefully through this changing legal landscape. But, as I'll demonstrate, the leading online genealogy providers have established rules protecting privacy even beyond what is required under American or European law, as a result only of market considerations. On Ancestry, which allows users to build individual family trees, the default setting is public for deceased profiles, which means that other subscribers can view all content in the tree except information about living people and notes. That's the default. There are two additional levels of privacy that one can select to make the tree more private. Trees designated private cannot be viewed by other subscribers, but limited information about deceased individuals in the tree, such as name, birth year, and birthplace, will appear in search results within Ancestry sites. For added privacy, one can prevent the tree from being indexed and found in searches. The tree owner can invite others to share the tree and also decide whether to allow invited members to see living people. Public trees on Ancestry may be searchable via Google and viewed by non-subscribers on the historical person search pages that Ancestry allows Google to index as part of its marketing and promotion activities. However, as far as I can tell, there is no way to guarantee that your Ancestry tree will be discoverable in a Google search. It's sort of hit or miss. MyHeritage protects privacy in much the same way as Ancestry. Its privacy policy states, quote, "We recognize the sensitivity and confidentiality of information that may be disclosed by users in registering, making purchases from our website, or performing their family history research, and we are firmly committed to protecting your privacy," unquote. Each tree has a webmaster and site manager who can invite others to join the tree as members or guests. Living profiles have their first names, dates of birth, gender, and photos hidden unless the user has been given access to the tree as a member. However, unlike Ancestry, on MyHeritage, users without access rights can still see the last name of a living person on the tree. Users have a host of privacy options regarding access and content, including whether to allow people to find the tree or request membership, include the tree in the MyHeritage search engine, enable smart matching with other trees on MyHeritage or its partners like Genie, and whether guests can view the tree or search, view, or copy photos. Like Ancestry, information from public profiles on MyHeritage may or may not appear in Google searches as a result of the company's marketing efforts. Genie, which was acquired by MyHeritage in 2012, operates an online collaborative tree that requires somewhat different rules. Genie's World Family Tree presently has over 115 million connected profiles with well over 4 million users all working together on the same tree. This is where I do most of my work. On Genie, profiles are divided into two groups, public and private. In general, living people are private and deceased are public. Genie will permit users to make even deceased profiles private, but they may be made public again by other users or curators, especially if the person in question was born more than 150 years ago. Celebrities and other public figures who have been designated as master profiles by one of the Genie volunteer curators are also public, even if they're living. So you can find Hillary Clinton or Donald Trump on Genie's tree. A user can make his or her own public profile public as well, so you can make yourself public. Profiles that are marked living but which are presumed deceased because the birth date is several hundred years ago are also made public. Private profiles can be viewed by people inside the family group of the profile, which is defined as fourth cousin or less. Additionally, curators and anyone who has been added into the family group of a manager of the profile can view and edit the manager's private profile. Genie's volunteer curators sign non-disclosure agreements and agree to keep private information confidential, but are given access so they can assist users and resolve issues in the trees. In contrast with Ancestry and MyHeritage, public profiles on Genie are fully indexed and searchable on Google, all of them. And Genie's search engine optimization is quite good, so the profiles often appear high on the Google search results. Genie allows a limited right of erasure, such that individuals may request deletion of their own profiles and those of their surrounding immediate relatives, subject, of course, to the possibility that someone else will add them back to the tree. I've described the policies of Ancestry, MyHeritage, and Genie from the perspective of those who want privacy. But what about those of us who want to publish their trees and are not concerned with privacy? Because of the privacy restrictions imposed by the various companies, there is no collaborative online platform where you can publish your tree openly without restrictions. The only option for a public family tree is to have your own website. Programs such as Reunion or Family Tree Maker will build web-based trees that you can then upload to your own website. People who want a public tree frequently use this option. As I've demonstrated, companies such as Ancestry, MyHeritage, and Genie have developed privacy standards not as a result of legal requirements, but as a marketing strategy. Again, there is no law in the United States or Europe that requires any portion of any family tree to be private, or that prohibits anyone from placing a fully public family tree, including living people, including minors, on the internet. Not only are there no laws restricting online family trees, but the online companies are protected from any possible lawsuit or liability as a result of Internet safe harbor rules, which prohibit lawsuits against providers of online forums for users who post their own data. The limited number of European cases on the right of erasure so far concern deletion of links to embarrassing criminal and debt-related items from search engines, somewhat in line with the earlier common law cases discussed earlier concerning public disclosure of private facts. To my knowledge, there has not been any case brought in the United States or Europe concerning an online family tree, nor could there be under the existing legal regime. The Internet has greatly changed our notions of what is private and what is public, and it has changed our notion of what it means to publish. Access to information has exploded. What formerly was known and available to a smaller circle of local friends and neighbors is now accessible to billions of people across the globe simply by putting it on a website. Many people are still adjusting to this new reality. The more paranoid and narcissistic among us have become even more so. There is a tendency for us to want to believe that everyone else in the world thinks we are as interesting and important as we are to ourselves. But that is obviously not true, and there is a good reason not to become carried away. It used to be that when the government collected information about a person, it meant that someone somewhere had identified and targeted that person for surveillance. We established safeguards against unreasonable, warrantless searches to prevent abuse of that power. But we should not pretend, in my view, that our concerns should be the same when the government engages in mass, untargeted data collection. Alarmists like Edward Snowden and Glenn Greenwald and companies selling security products, like the one quoted in Jan's presentation, have preyed on our natural narcissistic paranoia and our inability to comprehend large numbers to stir up demand for greater privacy protections. The truth is that no one cares about any of the things that we are trying to hide. 7 billion people may have access to your date of birth or mother's maiden name, but is still just your neighbors, friends, and relatives, the ones you're trying to find, the people who are already connected to you and know you exist, who will ever look for you and find you online. It's time to start thinking about what it is we're doing when we give people the right to erase and hide facts about their lives and prevent other people from finding them. Scientific inquiry, freedom of thought and expression, artistic freedom, the ability to analyze history and discuss issues of public concern, all of these are human rights as well. For genealogists, especially those of us committed to the idea of building a world family tree, it is time that we spoke up and defended our own rights and interests. Outside of the publication of objectionable private facts, there really is no such thing as privacy in the context of a family tree, nor should there be. Thank you. We're both willing to answer questions, and thank you very much. You are all very, very attentive for this long and informative discussion.
And at the end of the day, which all of us would like to be taking a schlafen instead.
Yes. So in the back, there was the first question. Yeah, no, that's an issue. On most of the websites, they rely on a user then to mark someone as deceased. On Genie, we often have the issue where, because there are 4 million users on the tree, a user dies, it happens, and then someone else needs to get access. And what you need to do is contact a curator or report under the actions menu. You can report someone as deceased. So you tell Genie, this user is no longer alive, mark them deceased. Their profiles will get transferred, the management will get transferred to someone else. So Genie has sort of a formula for that, but I agree there may be areas of the tree that will be sort of dormant for 50 years and people will be marked as living. What Genie does is it says if the birth date is included and the person is over 150 years old, they make the person public automatically, even if it hasn't been marked deceased.
How many of you have notes in your genealogy? I put a lot of stuff in my notes, okay? I share my tree. My tree is not online. I'll be the first one. I know Randy disagrees with me vehemently. I'm one of those people who do not put my tree up. My family doesn't want their information up there, and that's fine. They were kind enough to share it with me. I respect their results. I don't want everything that enough people know enough about me that they don't need to know what they don't know about me, okay? But I've also put in my will who gets my genealogy, okay? And it's different for different branches of the family. My parents were divorced. So giving it to my niece, who we had the same sisters, we were my niece's mother was my sister, but we had different fathers, okay? So she was really my half-sister, but she was really my sister, if you understand. So I have somebody on the paternal side getting the paternal one, and I have somebody on the maternal one getting the maternal. It's going to be their responsibility, even though no one in my family is interested in genealogy, especially to the level that I am, but they are told that they have the responsibility to share it within the family. It's going to be their responsibility next about what they do with it, where it goes. I'm not going to know. There are people who are Holocaust survivors who are very private. They lived through an era that I can't even totally imagine. So I can certainly understand their fear of some governmental agency someplace taking the information and misusing it. We live in a different country than the European countries had to go through with World War II. I also have friends who are first generation of Holocaust survivors. Okay, I know that some of the angst, and I don't know what other word to use, has descended down, and I can understand that my girlfriends, some of who were born in displaced camps, have a totally different view of the world than I do because I was born here. And you have to respect that.
So for 10 years, I was president of the Los Angeles Museum of the Holocaust, and I've met my good share of Holocaust survivors, and I really haven't met any who are that concerned that they want to hide themselves, at least the ones that I've met. Most actually would like to find family members, and public trees are really the #1 way to do that. This issue, however, comes up a lot in Europe, and it comes up not so much with the people you're thinking of, but of the people who survived by changing into Christians, for example, and don't want people to know that they have Jewish background. And that, I think, is what's driving a lot of the privacy concerns in Europe in those communities. So you have people who are hiding their Jewishness. I don't think that's necessarily good for the Jewish community, and I think, sorry? Well, it's not for them to decide either. That was the point, right? So it's everybody's alive, everybody exists. You can't hide the fact that you exist. No man is an island. And the fact that someone has a Jewish grandparent, it's more common than people think. And the more we talk about that, the less of a stigma is attached to it, and the more protected all of us, I think, are. So that's my view, is that regardless of what someone who is maybe converted and doesn't want anybody to know they're Jewish is concerned, it's totally fine. If that person's my cousin, I'm going to say they're my cousin, right? And if they don't like it, they have their view of the world, I have my view of the world, but they don't necessarily control what I get to say. And if I say that they're my cousin, that's my right, right? So that
you have just found the point where Randy and I disagree, because I happen to agree. It is not my place, if they don't want to be out, whether it's outed that they're Jewish or outed that they're gay or outed for any reason, it's not my role. It's their personal life and it's their determination. Randy has a different opinion, and neither one is right or wrong. It depends on how you personally feel about it.
There's no legal issue there. So, yes, Harvey? Yeah, we'll get there then.
Amen.
Yeah.
Amen.
But right now you can't access birth records of people who were children in the Holocaust in Europe very easily. And so for every one person who's trying to hide, there are 10 people trying to find. I err on the side of the people trying to find, but I understand it's a balance. Right now, the governments in Europe are basically against disclosure, and so we're going to not be able to find and put together families until too late in many instances. Yes, sorry. That's my view, that we think everybody cares about us, but really no one really does. Yes.
As one of the final things I said on my slide, it's up to each individual. I have to live with myself. I will not out somebody, whether it's for religious reasons or sexual reasons or whatever. If they have told me that I can put it out there, like the example I used, the 3, that's fine. I'll give you a different example that has nothing to do with religion or sex, okay? And how I feel you protect the living. One of the, my grandmother's sister had 13 children. Number 12 was daughter Deborah. And I was talking to Deborah, and she was very much an activist during her life. And so she ended up getting married to, she comes from an ultra-Orthodox family. Married a very nice Roman Catholic Irish gentleman who was the editor of the New York Post. She went to her oldest sister. Now, back you, this is in the early, like 1929, 1930. I mean, marrying out of the religious was a real shanda, okay? So she went to her oldest sister named Rose and said, I'm going to get married. I'm going to tell Mama and Papa. And Rose told her, and I've had this verified by enough members of the family that I know it's true, you're going to walk behind the coffin of Mama and Papa. So she concocted a story that she was going to fly to California, and there's a whole other story that I don't have time to tell about how she got off the plane in Philadelphia and came back by train so that her father didn't know who put her on the plane. She was living in New York. She never saw her parents alive again. And when I wrote all this up and I shared it with the family, Rose had one daughter who was still living. She was in her late 80s, and that woman's daughter saw it. And when her mother saw it, her mother went bananas. My mother would never do this. This woman's in her 89. I don't want her to die over this story. So her daughter contacted me. She says, what can you do to take this out? I said, this is what I'll do. In my master copy, the story stays. But when I share the tree from now on, that paragraph will be out until your mother passes away. And that's exactly what I did. Do I want to be responsible for an 89-year-old, she died when she was 93, but an 89-year-old having a stroke over this? No. Genealogy is not to hurt people. You sometimes obfuscate some facts until it is an appropriate time. I'm talking about not hurting the living.
Everybody has strategies. I've deleted 1 or 2 people who married into the family and didn't want to be on the tree at the request of a family member, for those very reasons. But I think the stories that you're telling are very typical of the stories I hear. It's never the person who objects who contacts you. It's the other one. Said, I don't care, but my mother is going ballistic. My sister would never want her kids on the tree. And the objector never objects. It's someone else trying to protect someone else. And I bet the woman, the 89-year-old, didn't care as much as her daughter.
Oh, yes, she did, Randy.
Okay, I bet.
I got to see her afterwards, and she chewed my tushy off.
Yeah. It's the protector of the family that usually interferes. And by the way, they're denying all of this information to the rest of the family, and that's it depends whether you want to give that information. That's right. I generally don't put stories, I put facts, so it's okay. Yeah. Okay. So I'm not talking about those stories. I'm talking about people who say, I don't want my kids on the tree. That's what I'm talking about. So but it's not Lashon Hora. They have kids. Sorry. I'm sorry. You said you didn't want to debate, so let's not debate it. Thank you. It's really up to you what you want to put on there. My whole point is I'm not forcing anybody else to do anything, but likewise, no one should be forcing me what to say or telling me what to say and not say. If you want to do it, and someone else objects, make up your own mind. But I used to get all the time, I'm going to sue you unless you put this down. So I'm a lawyer, so I looked up the law. I said, you can't sue me over this, or you can sue, but you're going to lose, right? And the fact is that you cannot boss other people around. You cannot tell them what they can and cannot say. And telling people what to say on a family tree is that type of bossiness, and that's not permitted under our legal system. It's permitted in our family system. And so sometimes you're in a family situation where someone actually can boss you around. If my mother told me not to do something, I would take it off the tree, right? Because I'm her son. But that's a different story from the law. That's the euthanasia program, for those of you who aren't familiar with it, yeah. Yeah, it's always who has the right, and I look at it, admittedly, from a broader perspective. There's one person complaining, but I haven't heard yet from all the other people who might want to have it on the tree, or the people in the next generation who aren't even born yet. And when you're making these decisions on whom to memorialize, the person who was killed is dead, right? So you're talking now about the grandchildren or the great niece who doesn't want to be reminded. But should that person's sensitivity really prevent the memorialization of this person who's been killed? Maybe not. And you're right, it's a balance. At the moment, in terms of data protection, the balance is in favor of protecting the person who wants to hide his or her Jewish background against the people who want to discover who their relatives are. And so, yes, you're protecting the sensitivities of people who are still hiding, but you're also at that time, I think, need to be aware that you're preventing the reunions that we all talk about when we get to our meetings. So it is a balance, and I don't know, in Europe there are not enough of the Jews to speak out in favor of the other side, which is for every one of these people who doesn't want anybody finding them, there are 15 who really want to find and need access to these things. But you don't hear that so much, I think, in Europe, so that's why I talk about it. I guess last question. I think we're over time already. Yes. Yeah. I like to tell I joke with my kids when I'm doing genealogy, which I do often on other people's trees, whether they like it or not, and I just say they can't hide. They think they can hide, but in today's world, you cannot hide, and I think genealogy proves that. Thank you, everybody, for coming, and thank you for coming to the conference.